section of the State Bar of Michigan, and welcome to this panel discussion on trading in music, law, business practice, and cross-border issues. Thomas, can you hear me okay?
Can hear you loud and clear.
Assuming good. We are truly pleased to have with us panelists Anna Bonnie Chauvet out of Washington, D.C., Tim Matson out of Minneapolis, Minnesota, and Hillel Frankel out of Nashville, Tennessee. Hillel will be moderating as well as presenting. I will briefly introduce Hillel, and then Hillel will introduce Anna and Tim. But before I do, I have one announcement, some procedural matters, and an acknowledgement. First, the international law section has more events upcoming. And most importantly, there is the second part of this panel discussion, that is to say part 2, which addresses similar but even more expansive subject matter next week. That takes place at this time next week. Please register using the program announcement that you received. There will also be other events upcoming. April 7th, we will be launching into a series on international dispute resolution, beginning with Africa and continuing later with the Middle East. With regard to procedural notes, first, so that the discussion runs smoothly, please mute yourself, as Thomas asked, when not presenting. Submit questions via chat to the host, and that is me, and I will bring them into the discussion when Hillel directs. Shortly before 1 p.m., I will interrupt the discussion to bring it to a formal end. After that, panelists, you may drop off. You may also stay on if you prefer. We will continue the discussion for those of us who remain, and I will remain on for up to 1:30. But anyway, we'll bring it to a formal end at 1, and at that time, feel free to leave if your schedules require. And also feel free to stay on. For those who have to drop off early, we will be recording, and we will distribute a link to our YouTube channel where you can watch the entire discussion or rewatch it. Lastly, I would like to acknowledge Attorney Liz Storm. Liz Storm is an ILS council member, and she specializes in precisely the set of topics that we will cover today and next week, namely music law, business practice, cross-border issues. And I acknowledge her for 3 reasons. First, she came up with the idea for this panel and the scope of its subject matter. Second, she assembled the panelists. And third, many of you are in attendance here today because she directly or indirectly informed you. So we thank her for her extraordinary efforts in putting this together. I have long contended that attorneys who practice international law are the most interesting attorneys. But I have recently met a few attorneys who practice in the area of music law. And because of that, I am challenging my prior assumption. And with that, I'm going to introduce Hillel Frankel, panelist and moderator, who is one of those people who are, in fact, seem to me even more interesting than international law practitioners. Hillel is a partner at the law firm of Mandell Menkes. He runs their Nashville office on Music Row. Hillel's clients include artists in the genres of Americana, folk, EDM, blues, soul, reggae, R&B, and rap, as well as producers and indie labels and indie publishers. Hillel represents artists and music companies on copyright and trademark issues and performs transactional work on music publishing and master licensing for sync and advertising. Hillel is a regular speaker and panelist on intellectual property issues at conferences and festivals. In his not-so-former life as a musician, Frankie Hill, he recorded and toured internationally on keyboards and saxophone for numerous bands, including the Grammy-nominated Liquid Soul, LA's Bone Daddies, and Chicago's P1 and Heavy Manners. He can be heard around Nashville, sitting in with various groups on tenor sax. And that is why I feel that music law attorneys may even be more fascinating than international law attorneys. With that, I turn it over to Hillel, and thank you.
Thanks for that introduction, Elliot. And that may be because we start elsewhere and end up in law, which happen to be. But I do hear a bunch of noise. I'm not sure if that's people who are not muted. If it's possible, everybody try and mute themselves. We are going to discuss copyright and also royalty issues that arise from that, including mechanicals, performance royalties, Tim is going to handle sync royalties and sync issues. But we're going to start off with Anna from the Copyright Office. And let me pull up the introduction for her. Anna serves as Associate General Counsel at the Copyright Office and works on a wide range of legal and policy matters pertaining to copyright. Most recently, she spearheaded 4 rulemakings to implement provisions of the Orrin Hatch Bob Goodlett Music Modernization Act, the MMA, related to the new blanket license regime and pre-1972 sound recordings. Among other things, she provides legal guidance to the various divisions and programs of the Copyright Office and counsels the U.S. Department of Justice regarding positions to adopt in federal copyright cases. Prior to joining the Copyright Office, Anna worked for more than 8 years in private practice, representing entertainment, banking, and technology clients on copyright, trademark, and/or patent matters. Okay, let's get rolling. Anna, I'm looking for you on here. Let's see, where are you?
I'm here.
Okay.
Thanks, Hillel. And thanks so much, Elliot, for having me speak today. I'm really excited to be here. So I serve as Associate General Counsel at the Copyright Office. So today I'm going to give an overview of U.S. copyright law, how it relates to music, but also I'm going to talk about a few of the players in the music ecosystem so that when Hillel and Tim start talking about licensing, you'll maybe already have an introduction and some context for that discussion. And then I'm also going to give a very high level overview of the Music Modernization Act, or the MMA, and the recent changes that has brought to music law. So let me go ahead and share my screen. All right. Let's see. 1 second. All right, so can you guys see that okay? Elliot, you can just give me a thumbs up if you can. Okay, great. All right, so copyright law, or whoopsie, sorry, I should go back to that. How do I go back? Hold on 1 second. Give me 1 second, sorry. All right, so copyright is a form of protection that U.S. law extends to original works of authorship. So music, such as like sound recordings, musical works, literary works, dramatic works, and copyright protection in the United States is effective as of fixation. So the date or the time when that painting is finished or when that book is actually written. So I wanted to at least talk about like what copyright is to distinguish it from trademark law. So there's no commercial element to copyright or copyright protection, and we're not talking about inventions, which is more in the realm of patent law. For music, there are 2 distinct works of authorship when we're talking about a song. You have the musical work, which is the underlying composition, which is created by the songwriter or the composer and the accompanying lyrics. But you also have the sound recording, a particular performance of the musical work that's been fixed in a recording medium, such as a CD or a digital file, which in copyright is referred to as a phonorecord. So for example, you have Otis Redding's musical composition, Respect, and then you have Aretha Franklin's particular performance of that particular song. So not even just like musical works or sound recordings. For all copyrights, the copyright owners have certain exclusive rights. For all works, that they have the right to reproduce the work in copies or phonorecords, to prepare derivative works, which, for example, if I were to write a book and then wanted to go ahead and have a movie or a screenplay developed based on that book, that screenplay would be considered a derivative work. And also, they have the exclusive right to distribute phonocopies or copies of the work to the public. So for musical works, the underlying composition, those copyright owners also have the exclusive right to perform the work publicly and to display the work publicly. And for
Anna, if I may interject just quickly, are your slides advancing at the rate of your presentation?
You should be seeing, they are to me. For all work, so I'm what you should be seeing is a page that says, there's a picture of a gentleman with a guitar. Are you seeing that?
No, we're seeing what looks to be the first slide, which has your name and title.
Okay, so I'm going to try to do something else. And I'm going to share a PDF version. Let's see if I can. All right, are you seeing a different change now?
Yes.
Okay.
Now it says copyright basics.
Okay, perfect. I'm very glad.
Thank you.
I'm going to jump over this because I've already talked about this. Again, you have the musical work versus the sound recording. And then this was the specific slide where we're talking about the exclusive rights that a copyright owner is afforded. So for all works, they have the right to reproduce the work in copies or in phonorecords, like if phonorecords being a CD or a digital file, for example. They have the right to prepare derivative works, and they have the right to distribute copies or phonorecords of the work to the public. For musical works, the copyright owner has the exclusive rights to perform the work publicly, to display the work publicly, and then for sound recordings, the owner has the right to perform the work publicly, but by means of a digital audio transmission. And this is a key for sound recordings. So for example, there is no what we would call a terrestrial right for sound recording copyright owners. So when you are hearing a song being played on the radio, the musical work owner for the underlying composition would be receiving a royalty because they have the exclusive right for performance of their work publicly. But a sound recording owner does not in that instance because they only have the right to perform the work publicly by means of a digital audio transmission. So when we're talking about interactive streaming, which we'll talk a little bit about in a minute. So I'm a very visual person. So this is another way of thinking about musical compositions and sound recordings. So for each of those works, they're going to have a public performance right, and they're going to have a reproduction and distribution right. So it depends on which box you're in is going to be and depending on what your client wants to do, will be telling you what type of license you need to acquire. And I purposely left these boxes mostly empty because Hillel and Tim are going to be talking about licensing. But two things I wanted to point out. We're going to talk a little bit about the Music Modernization Act and this new entity called the Mechanical Licensing Collective, which administers the statutory license for musical work, so for compositions. So when we're talking about that, that is going to be in your left upper box. So it's a very targeted area of copyright law and licensing. And then the other thing I wanted to point out is when we're on the sound recording side, in the lower right-hand corner, you're going to see, again, a split between digital and analog when we're talking about public performance royalties. And even within digital, there are different ways or manner in which the interactive versus non-interactive streaming is licensed, which we're going to talk a little bit about, and Hillel and Tim will probably talk more about. And then again, because there's no terrestrial right for when songs are played on the radio for sound recording copyright owners, no one gets paid in that box. And so that is not something that radios have to license. So it's just another way of kind of thinking about what your client wants to do, which box you're in, and which type of license you might need to acquire. So the exclusive rights that copyright owners have are subject to certain limitations, including statutory licenses. And a statutory license just allows users to use the copyrighted work without direct permission from the copyright owner, as long as they follow some, certain record keeping requirements typically and some reporting. So the Section 15 mechanical license is to reproduce and distribute musical works embodied in phonorecords. So when we're talking about interactive streaming on Spotify, I go to Spotify, I select the song that I want to hear. We're in the interactive streaming section. This is when this license is going to be relevant. And then on the sound recording side, on the public performance side, So again, the lower right-hand box of the previous screen, we have the section 112 and 114 licenses regarding public performance of sound recording by means of non-interactive digital audio transmission. So an example of a non-interactive digital audio transmission would be like Sirius XM, where it's almost like you're turning on the radio and you don't know which songs are coming next. That would be an example of non-interactive digital transmission. So the section 115 mechanical license, as I've said, it involves the musical right, the work reproduction and distribution rights of that work. It was created in 1909 to prevent monopolies in mechanical music, which at that time involved piano players. So it's a very old part of the Copyright Act. And before the Music Modernization Act changed things, users wanting to license the mechanical right for a composition had to do it on a song-by-song licensing basis. And if the musical work was not in the Copyright Office's records, the copyright owner was not entitled to a royalty. And as we'll talk a little bit about in a minute, royalty rates for the Section 115 statutory license are set by the Copyright Royalty Board. So as I said, the Copyright Royalty Board decides the rates and terms for certain statutory licenses, including for music, cable, and satellite. And it is part of the Copyright Office. My office specifically interacts with them occasionally if they refer a novel question of law to us, or we will conduct a statutory review of final determinations relating to rate setting, and they can be appointed and removed by the Librarian of Congress. So I'm talking just about the Copyright Royalty Board merely to introduce them as a player in the larger ecosystem relating to music and licensing. So just a general overview of licensing, what I think is really interesting that most people don't appreciate is that it's a very heavily regulated industry. So on the sound recording side, you'll see that certain rights like the reproduction and distribution right and the digital interactive performance right, those are freely licensed and negotiated. Whereas if you turn on the musical work side for those same rights, that those are going to be regulated and the rates are going to be set by the Copyright Royalty Board, or in the case of performance, we'll talk about them in a minute, but then you're going to have them set by rates courts because you're talking about slightly different rights. And that leads us to discussion of performing rights organizations, or PROs, which collectively license and collect and distribute royalties for musical works public performance right. So I introduced them because, again, these are players that when you or your client are looking to use music in certain ways, for the public performance right of musical compositions, a license would need to be obtained. And very often that would involve one of these PROs. ASCAP and BMI collectively have most of the market, but there are also CSAC and Global Music Rights, GMR, which also collectively license and collect and distribute royalties on behalf of their members. So they're just another player or players for you to be aware of. So very briefly, concerns prior to the MMA. It's interesting to discuss them because it explains why things are the way they are. But ultimately, copyright owners and authors were very dissatisfied. They were not getting paid. They felt like the digital streaming services were missing and not paying for licenses. And there was a lot of litigation. I also wanted to point out, in case you're interested, there are 2 policy reports that the Copyright Office authored relating to the protection of pre-1972 sound recordings and music licensing in general. Though some of these, I guess the information in the reports is now outdated, given that the MMA has replaced them, but they are useful background in case you're interested in knowing more. Okay, so the Music Modernization Act, it is made up of 3 titles. the Title I Musical Works Modernization Act relates to the Section 115 mechanical license. It creates a blanket license for digital phonorecord deliveries, whereas, as I was saying before, pre-MMA songs had to be licensed on a song-by-song basis. You have Title II, which relates to the protection of pre-1972 sound recordings. And then finally, Title III is the AMP Act, which allows music producers, mixers, or sound engineers to receive royalties under the Section 114 statutory license. So we're going to talk first about Title I, which, as I've said, it creates a blanket licensing system for digital music providers, or DMPs, which replaces the prior song-by-song licensing system. In order to have this blanket licensing system, there is a mechanical licensing collective, which was designated by the U.S. Copyright Office, which is going to be paid for by digital music providers, and that will administer this new blanket license for the mechanical license. So again, we're going from this previous MMA song-by-song licensing system where you're suddenly going to have this blanket, or I should say we now have this blanket license available because it became available on January 1 of this year. So just as an aside, you should know that direct licenses will remain in place and that the pre-existing song-by-song licensing, which was relevant for CDs and vinyl, that is still going to be in place now that the MMA has been enacted. Just a little bit of information about the Mechanical Licensing Collective, or the MLC. It is a single nonprofit entity created by copyright owners. There are certain criteria that had to be met for the U.S. Copyright Office to designate the current entity that is going to administer the license. So the Copyright Office issued a number of regulations to implement provisions of the MMA. And I'm not going to talk about all of them, but I did want to flag that there is one relating to the creation of a public musical works database. Under the law, the MLC, the Mechanical Licensing Collective, or the MLC, is required to build and to maintain this public database. It's free, it is online, it is available at the MLC's website, which is themlc.com. And we did a rulemaking to determine the categories of information to include in the database besides the fields that were statutorily required. Our regulations also require the MLC to make bulk access to this database available through APIs at a marginal cost as dictated by the statute. And the MLC anticipates being able to do that by the end of this year. And we also had a number of regulations regarding the transparency of this new entity, the MLC, through annual reporting. So that's Title I, which deals with the licensing of the mechanical license for musical works or compositions. I'm going to turn quickly to Title II of the MMA, which concerns pre-1972 sound recordings. Before the MMA, there was no federal protection for U.S. pre-1972 sound recordings. And so with the introduction of the MMA, certain protections have been extended to those works. It's not copyright protection, but it does afford them certain exclusive rights that sound recording owners of post-1972 sound recordings have. And it also extends certain for them to be able to go ahead and file for certain remedies, I should say, if there's unauthorized use of their pre-1972 sound recordings. It also, under the MMA, establishes, just to make you aware, I'm not going to spend not a lot of time talking about it, but it establishes a new non-commercial use exception for 1972 works that are not being commercially exploited. And the law also requires, in order to be able to get attorney's fees and certain damages, that the owners of this pre-1972 sound recordings file certain information about their works with the U.S. Copyright Office. Because this is an internationally focused group, I also wanted to flag that even before the MMA, even though pre-1972 U.S. sound recordings were not protected under federal law, there were certain foreign pre-1972 sound recordings that were under the Uruguay Round Agreements Act. So the Copyright Office hasn't come out with a formal position, but there's no mention of foreign sound recordings in the MMA. And so it seems that there is this parallel protection. So when you're dealing with pre-1972 sound recordings in the United States, you might just want to think about if you're dealing with a US work or if you're dealing with a foreign work, which might actually have full copyright protection. So the non-commercial use exception that was created under the MMA, it allows users to engage and to use a pre-1972 sound recording if they conduct a good faith reasonable search and find that the sound recording is not being commercially exploited and the sound recording owner does not object by filing an opt-out notice with the Copyright Office within 90 days. So there's more information about this, I think even in some of the materials that might have been distributed before this presentation that the Copyright Office has put together, which details like what the steps are, what constitutes a good faith reasonable search. And I would urge you, if you're interested in taking advantage of this exception or your client, that you go ahead and look for more information there. And that leads me to, here are a bunch of materials and resources that the U.S. Copyright Office has developed specifically about the MMA, about the different things that need to be taken into consideration and how the law has changed since the momentous enactment of this great legislation. So that is kind of the overview of domestic copyright law. I will go ahead and turn it back over to Hillel and to Tim to talk more about licensing.
All right, thank you, Anna. That was really informative, and those slides are terrific as well. Are those slides available for download to any of our viewers? Oh, you're on mute. There you
go. They haven't been available yet. I will circle back on that.
Okay. All right. And Elliot, are there any questions for Anna from the?
Well, just one. And so you had an interesting slide on what areas of licensing are regulated and what aren't regulated. It seems like maybe half were and half weren't. Is there any, what is the rationale for deciding whether it should be regulated or it shouldn't be regulated? For what reason is that does that dichotomy exist? And I think you're on mute still. And thank you for being so alert to being on mute.
Sorry, I keep not wanting to have the background noise. So that's a really good question. And I think what's interesting about copyright law in the United States is in some ways kind of patchwork. Like they'll pass certain laws like the MMA, which deals really like basically for the most part with the mechanical license, which is a small part of the licensing system. And so I feel like some of it is lobbying, but some of it is just how laws are actually created and what they address at different times, which has created the current systems, which leads to, as you're very rightly pointing out, like certain things are much more freely negotiated and some are not, and it doesn't seem to be like a true reason why.
Historical then. Thank you, Anna. That's all. Hello.
All right, then let me continue. I'm going to kind of direct this more towards applicable to copyright holders, copyright owners, maybe publishers, record labels, and discuss licensing and royalty issues. Kind of on a more practical basis for people who are representing songwriters, publishers, and for people who are maybe representing record labels or recording artists who are independent. So there are 4 direct types of licenses. I'm going to focus more on the composition side because the sound recording side is often freely negotiated between the parties that are doing the licensing, and those rates can vary. But in terms of licenses and royalties available in the recording of a musical composition, there's really four key royalty streams, and that's mechanicals, performance royalties, synchronization licensing, and print. And I gave a bit of a background on mechanical and performance. I'm going to go into that a little more. Tim is going to speak on synchronization licensing, and print really relates to printed music and to a certain extent lyrical reproduction, but we're not going to address that really right now because that really there haven't been many changes in that lately. But let's kind of start with mechanicals. A mechanical license is required, and a mechanical royalty is generated whenever a composition is mechanically recreated, like in a download or in an interactive stream, a stream that you select to hear. Physical copies such as CDs and vinyl also involve mechanicals, and those continue to be administered by the Harry Fox Agency for the most part. Certain publishers administer their own mechanicals for CDs and vinyl, but the Harry Fox Agency has, I think, 90% of the titles, and that's a good source, the harryfoxagency.com, for licensing if you're going to create CDs and vinyl as a label or even as an individual artist. Because remember, although you may have created the sound recording, the record label may have created the sound recording under a work for hire agreement, or the artist may have created the sound recording by paying an engineer or producer. The composition also has to be licensed, especially if it's published by somebody, or if there are co-writers, or if it's administered by a performance rights organization. So that's the other key royalty here, the performance royalties, and they're generated whenever there is a performance of the song. And the performance of the song could be digital from the streaming service, or it could be performed live, for example. That's why you have ASCAP or even streamed online, live performance on one of the different platforms. So that's why ASCAP, BMI, CSAC, and Global Rights, they all collect on behalf of the songwriters and publishers that control those compositions. And those are done with blanket licenses. We'll talk a little bit more about that in a minute. I want to get back to mechanicals. For digital mechanical royalty collection and administration, we now have the Mechanical Licensing Collective, the MLC, which Anna was talking about, which was created as part of the Music Modernization Act in 2018. The MLC provides blanket licenses for streaming services. It provides a baseline structure to ensure that royalties are actually collected and distributed to the rights holders of those copyrights. As of January 1st, the MLC began administering new blanket mechanical licenses for streaming and download services. The MLC also officially started to collect mechanical royalties for digital mechanicals, including collection from all of the streaming services. The MLC is responsible for matching those royalties that come in from the streaming services to the copyright holders. And the copyright holders could be, this is on the composition side, the copyright holders could be the publishers, or they could be independent songwriters. To that end, the MLC has launched a comprehensive public musical works database to ensure transparency and accuracy of paying the proper parties for each song. So they've started with the Harry Fox database. They're sharing the database for mechanicals with Harry Fox, who were traditionally administering physical mechanicals for physical and some digital, and they're now making available to publishers, indie publishers, and individual songwriters like me, for example, because I have co-written a bunch of compositions that are out there. If I wanted to register and be paid for my musical works, for performances of those works, and for mechanicals on those works. For mechanicals, I would go to the website is themlc.com and sign up as a copyright holder. They ask you to verify your information. You give them payment information. They do a certain tracking of what songs they see out there in the public marketplace, maybe that they got from Harry Fox. And then you can also add compositions. And they're through that method, they are able to allocate a percentage of the streaming royalties that are coming through and pay you a digital share. A little bit more specifics on that. Let's go here. How are the royalty rates determined? What do writers and publishers get paid? For royalty payment, streaming services, mechanical royalties go side by side with the public performance royalties, which is the performance royalties, PROs that we were talking about, making what is known as an all-in royalty pool. In the US, the all-in royalty pool is currently set at 11.8% of streaming, of the streaming revenue, streaming platform's total revenue, with a plan in place to increase that percentage to 15.1% in 2022. However, the streaming services, specifically Amazon and Spotify, appealed that rate, and they won their appeal. So the streaming services, the result of that, the result of the appeal is that the court sent it back to the CRB, the rate court, to determine what the rate should be for mechanicals moving forward. And as of today, they've reverted back to the original rate of 2018, which I believe was at 10.5%. So 10.5% of revenue is reserved for a combination of mechanicals and performance royalties. Once a decision comes down as to what the current rate will be, and also the basis of how that rate will be determined, there's argument as to how the streaming services have to calculate what is their full gross income, or whether it's different, different categories of revenue, how they divide, how they come up with their payment on that percentage. But once there's a full determination of the rates and the terms by the CRB pursuant to the remand that is happening as a result of the appeal, those final rates and terms will be used by the MLC and will also apply retroactively back to January 1st, 2018. So royalties on the mechanicals and performance side could either go up or down, depending on which way this hearing goes. Maybe Anna has an update on that. Right now, I think we are waiting for a decision by the Royalty Board in consultation with the MLC, with the Mechanical Licensing Commission. The other piece to this is the share of the public performance royalties, the PRO share, ASCAP, BMI, and CSAC, is the subject of negotiation between streaming services and the performance rights organizations. It's usually around 6 to 7% of the services revenue. We were talking about we were at 11%, then we're at 10%. Whatever is left after they determine the performance rate, that is what is paid out in mechanical royalties. And it's distributed between the songwriters of those songs at a per rata basis. It's not an insignificant sum when you consider the amount of revenue that streaming has generated. I'll tell you, as a result of the creation of the MLC, the streaming services have distributed their black box funds, which is the amount of royalties that they were not able to figure out who owned on the composition side. They had been putting it all into an account, and the amount of that the black box fund over the years had grown to $424+ million in accrued historical unmatched royalties. So once the MLC was up and running on January 1st, the streaming services are transferred over a total of $424 million of black box royalties. The MLC is going to take in the royalty data after they, as they compile this list of compositions and rights holders, and make a determination as to what goes where and how much should go to who, and pay out that share of monies. I don't have the exact details as how they will make that determination. That would definitely be the subject of another panel. There's one more thing I want to point out on the international side. It's important to note that the MLC is collecting mechanicals on digital streams for US only. Foreign mechanicals are usually collected by a collective management organization of whatever country that you're dealing with. Europe has a number of different CMOs. There are important differences between how the CMOs operate and how the MLC operates in the US. For example, CMOs may represent works for many different types of uses and frequently many different types of authors. The MLC is responsible for administering licenses limited to a singular and narrow right concerning one type of work. In the US, that's musical works. That's the only thing the MLC collects on. And one type of use. And the use is a blanket license for digital phonorecord deliveries. So digital streams, digital downloads, all manner of digital transmissions through the services. The MLC also does not have members who choose to join the collective. The MLC automatically takes in all the data from everybody. You don't actually have to sign up for the MLC, for the Mechanical Licensing Commission to get Mechanical Licensing Collective to get paid. You actually are automatically included in their database, and if they have proper payment information, you will receive a royalty. CMOs, the organizations overseas, are generally affiliate based, just like ASCAP and BMI. You would choose to join them. Just going back a little bit on the performance royalties. So performance royalties, the royalties collected for the performance of a song. ASCAP and BMI generally have a set blanket rate for performances from, they have from terrestrial radio as well, and there's also from streaming, and also from live performance. So these are blanket rates that cover all songs. One of the reasons that there is a new, that Global Rights, for example, formed a new company is that they have tried to renegotiate better rates for their particular clients, who are usually pretty well-known writers and publishers, or pretty well-known writers, catalogs.
Hello, can I break in, just ask a question that came through on the chat?
This is a good time because I'm at a good break point here to turn this over to Tim. So go ahead and let's hear the question.
So first, someone asked that you repeat the name of the website for entering data into the MLC.
It is themlc.com.
Okay.
Hey,
themlc.com. Anna.
Yeah.
Really quick, only because the Copyright Office, we've had to interface a lot with the MLC because we are regulating the entity. So there's been a little bit of confusion. So I guess I just wanted to clarify a couple of things. One is the public database is available to everyone. It is available at the MLC.com. That is the website. It's what they call public view. Separately, there's the claiming portal, which is for like the copyright holders, so publishers, administrators. If you're a self-published songwriter, that is where you have to register to go in, and you do have to register with the MLC if you are going to get paid. If you are a songwriter who works with an administrator, the administrator, I presume, would do that on your behalf. But I just wanted to clarify the difference between the database and the claim.
Right, that's good. I'm glad you did that, and I wasn't actually clear as to whether they were going to pay, for example, if they're taking the database from Harry Fox, were they also getting payment information from Harry Fox? But it sounds like that you have to register in order to get paid at the MLC.com.
Yeah.
So quick follow-up question on that for both of you, Anna and Hillel. Do you have to have a registered copyright to register with the MLC, or can you have a copyright that's not registered?
Well, that's an interesting,
still get paid.
Because there is a common law copyright if you created a song. Do you have to have registered with the Copyright Office?
Yes, that's the question.
Anna, what do you think? Can you, if you've written a song but never registered the song, but you still are the writer, are you able to collect on that through the MLC?
Well, so U.S. copyright law starts at fixation. So it does not start at registration. Registration is a benefit, like I can go sue someone. For all intents and purposes, I'm not talking for the Copyright Office at this moment, but like if you want to be paid on your mechanicals, like you should register your work, because that kind of puts you in the system where if someone is using your work without permission, then you would be able to go sue and be able to enforce your rights definitely more easily.
Wonderful.
Yeah, and
Thank you.
Yeah, filing for copyright gives you statutory damages, and it gives you really, in order to enforce your copyright, you need to have the leverage of having a registered copyright to be able to threaten a lawsuit, to threaten collecting statutory damages, which could be much greater than the actual monies generated by the infringement. So that's key. But this is a good point, is that even if you haven't registered your copyrights, if you have a catalog of songs, you should make sure you're registered with the MLC, and that the listing with the MLC is the songs that they have listed matches what you feel is your ownership share. And I also, as I understand it, the MLC has a way to determine if there's a dispute as to ownership of a song. The MLC has a process it's probably similar to Sound Exchange, which I didn't actually get to, but Sound Exchange has a dispute provision where you can dispute a particular share of a track of a sound recording, and then they will look to the other party to respond as to who has as to whether they have a valid claim for that portion of the sound recording. I believe the MLC is going to work in a similar fashion, trying to determine exactly if there's a conflict, how to resolve that conflict.
Thank you. Thank you for responding to those. So once again, the site is themlc.com.
Right.
And with that, Hillel, did you want to turn it over to Tim, or was there more to say on this?
Tim here. Tim Matson is counsel at Fox Rothschild LLP. He is an experienced and skilled transactional lawyer, litigator, and intellectual property attorney with over 20 years of experience representing musicians, filmmakers, media talent, writers, visual artists, and other creators of artistic works in all aspects of their entertainment careers. He has worked with several legacy artists on copyright transfer termination issues, including the firm's filing of the nation's first post-1978 notice of termination. Tim also represents emerging and mid-sized businesses as they develop, market, and distribute creative content and technology, such as computer software, video games, and online products and services. He is an active member of the National and State Bar Associations and has served as chair of the Minnesota State Bar Association Arts and Entertainment Law Section. Tim is also a frequent lecturer and author on entertainment and IP issues. Take it away, Tim.
Thank you for that introduction, Hillel, and thank you, Elliot, for asking me to appear today. Just a quick shout out, the song was Funky Town. We filed the copyright termination in 2006, and that was, according to the Copyright Office, the first sound recording termination filed under Section 203 of the U.S. Copyright Act. So I'm going to talk a little bit about synchronization licenses, the last bucket of royalties and deals that songwriters and recording artists or their publishers and labels can get paid on. And so this is a license that permits a third party to synchronize your music with an audiovisual work, such as a motion picture or a television program or television commercial. As Anna pointed out, there are 2 copyrights here, and so you need to secure 2 licenses. One is for the master recording, and one is for the underlying musical composition. And as Anna also pointed out in her slide, the chart, there is no compulsory license or regulatory scheme for synchronization licenses. So ASCAP, BMI, CSAC, Harry Fox, the Copyright Royalty Board have nothing to do with what we're talking about here. It is an entirely negotiated license, and the copyright owner or owners can deny the license. Quick point for federal or U.S. law versus foreign. In the United States, a joint owner can separately grant a non-exclusive license to use a work, subject to the duty to account and pay the other right holders of that work. In Europe, it's generally the rule that you have to secure a license from all rights holders, even if it's a non-exclusive license. In the United States, of course, to get an exclusive right, you need all copyright owners to sign the license. And so there are a handful of different types of synchronization licenses. Exhibition, so public performance, say a film in a movie theater. Broadcast for television programs or commercials. Distribution of copies, such as video games for private home use. Streaming and permanent downloads on the internet. So when you're looking to secure a sync license or represent a copyright owner considering granting a license, there are various terms that you need to deal with. Of course, the first is the fee structure. Generally, sync licenses are a flat one-time fee, although they don't have to be, and they can be granted according to different rights being used. A copyright owner will earn additional public performance revenues on television performances. So the first big issue is the song itself, the value of the song. Popularity, historical significance. I've worked with a lot of legacy artists where you're talking about hit songs that somebody has to have. And so the issue of value is, do they have to have this song, this recording, or are there close substitutes if the demand for the fee is too high? And part of that, the importance of the song in relation to the intended use. I represent an artist who had written a song, it's called the Zamboni song. I Want to Drive the Zamboni, the Gear Daddies from the 1990s. And we were approached by MasterCard to license that song for commercials in Canada, where it was about a hockey player who wasn't very good and couldn't score, a bunch of different commercials, and they ultimately made it to the NHL because he was a Zamboni driver at the All-Star game. And so in that situation, MasterCard, the biggest ad campaign ever, they had to have that song. And so that will dictate, what you can negotiate. With respect to film and television, the scope of the intended use is important. Is it background music, foreground music? Is it the opening title sequence, or is it the credits? I represent the writers of a couple Whitney Houston #1 songs that I terminated the transfer, and there's going to be a new movie about Whitney Houston, and they want to use I Want to Dance with Somebody as the title of the film. So are you using the song title? Is it vocal or just instrumental? Do the lyrics help tell the story for the film or television show? Are you using the original recording, or is it going to be re? And then, of course, you have the scope of the license. Is it theatrical release or film festivals only? Do you want home video, streaming, downloads? You have to define the distribution channels. Many times, and I've represented filmmakers and also recording artists, for independent film, you may ask for a festival license with options for U.S. theatrical release and broadcast, where you only have to pay for the initial festival, and sometimes we get those on a gratis basis. And then, of course, the other important terms in sync licenses, is it a term of years or in perpetuity? Are you asking for U.S. rights or other jurisdictions? Is there a request for exclusivity? So, for example, in commercial uses, for television commercials, it's typical that the ad agency and their client will request exclusivity for that product line so that nobody else can use the song for the same product. For films, it's generally non-exclusive. And then one thing I do when I'm representing artists is request most favored nation status so that we get equal treatment for the highest paid song in a film, depending on the use. So I will stop there, and if there's any questions, I mean, there's a lot of information about rate structures and fees, and I want to give a shout out to the Braybeck brothers for their wonderful book, and I use it as well. But Todd and Jeff, here's a shout out for Music, Money, and Success, and it has a lot of information about negotiating these types of licenses, whether you represent somebody who wants to use music or the artist or songwriter.
Well, thank you, Tim. I will point out that the authors of that book are, in fact, on this panel. Well, they're attending the panel discussion. Jeff Braybeck and Todd Braybeck are, in fact, present. So feel free to chat with them after the formal end of the panel discussion here today, which will occur soon. There are a couple questions, but first there's an observation which came through the chat from Jeff Baybrek pertaining to dispute resolution. So Jeff pointed out that with regard to the MLC, they have published a dispute resolution procedure. And I imagine that Jeff may address that in more detail next week. Secondly, there's a question for you, Tim, regarding sync rights and how sync rights work on things like YouTube videos or internal corporate videos that aren't used externally. Is that still a public performance? So
you still have to clear, I mean, YouTube certainly is a public performance. Corporate in-house, it is still a use. You're still having the right, you still have to secure the right to make the copy of the audiovisual work and to sync the audiovisual to the music or sync those rights. So you do have to clear those. Now, as a technical matter, if it's an in-house corporate video, whether or not that's going to be found out if they don't do it is another question. But I counsel, corporate clients, yeah, you have to secure this right if you want to sync it. And certainly if you want to put it on the internet where it has public access.
And then there's another question from Dr. Juanitaulloa about whether you can explain equal treatment in most favored nation status. So if you can explain how that is articulated as a provision.
Basically, when you
or what that means,
you get a request for quote, you will quote a fee. The party that wants to use the music in a film or a commercial will ask for a quote, and you'll quote a fee, but you'll tie that quote to a most favored nation's request to say, I want to be treated better. If somebody else is making more money, I want that same rate. And so it's typically the rights holders who will make that request that if you issue a license for this film for the same use, if you get a license and you negotiate a fee that's higher than the fee we're quoting, you have to pay us that higher fee.
Thank you, Tim. And so we're approaching the end of the hour, and I'd like to give all three of you an opportunity to close, but I would also like to leave with a question on that. And it's, can you identify the big issues? And so here's the law, here's practice, here's how contracts are written. Where are issues encountered in practice? Well, what goes wrong and where are the misunderstandings, and how are they resolved? So if you can each address that in 30 seconds or less. No, I'm joking. But if you could comment on that or maybe point us to additional resources and simply close with your final comments, that'd be great. Anna, would you like to go first?
Mute. You're on mute, Anna.
You're still on mute. If you could start over, please.
Okay. Thank you. I'll be really quick. I have a hard stop. I have to leave at 1 o'clock. So as I mentioned, there are a bunch of resources available on the U.S. Copyright Office's website relating to the MMA, relating to copyright more generally. It wouldn't be appropriate for me to give like practice tips, but I will just say this. I think knowing, again, which box you're in, like which are license do you really need, because it will depend on what your client will do. But always think about, you have the musical composition, the sound recording, but then you also have to, under each work, think about whether it's a public performance, and if so, what kind, and then also whether you're talking about distribution and reproduction, to make sure you have all those licenses and clearances available.
Hey, thank you, Anna. So a number of people have requested your slide deck, and I know you said you'd look into that.
Yes, I'll do that.
And I imagine there might be some government approval necessary. But if you could get back to me and let us know if that's possible, I think the audience would appreciate it based on their comments. Hello.
Yeah, and supporting what Anna said, it's really important to distinguish between what licensing is already there as a result of a blanket license, so like mechanical licensing, performance licensing, and what licensing you need to negotiate, which is obviously synchronization licensing, but also in terms of if you're negotiating a record deal or a publishing deal, what the rates are for your royalties and for your work in different revenue streams. So the blanket licensing is usually going to be covered by the associations and the PROs. And I left out Sound Exchange. I didn't get to Sound Exchange, but Sound Exchange does administer the performance royalties for sound recordings, and it goes through all through satellite radio and through digital radio, and they also administer to producers as part of the MMA through a letter and through to featured artists. So it's a very important. We'll have another discussion about Sound Exchange. I also wanted to point out really quickly.
I want to just quickly break in here and just thank all of you. So I know we're at the top of the hour, and I want to give Hillel a chance to finish up, and then Tim a chance to close as well. But we are at the top of the hour, and so those who need to break, thank you for presenting, Anna, Hillel, Tim. It was a real pleasure. Thanks for sharing your expertise, and we hope to hear from you again soon.
Thanks.
And with that, we will continue the discussion. I will remain on the line, and those who want to stay may. Hillel, can you finish up and then pass the baton to Tim for a close?
The international side will be covered a little more extensively next week by the Breivicks and the other panelists. So if people were waiting for more information on international, we didn't get to too much of it here, but it will be covered next week. And to that, after that, I'm going to turn it over to Tim, see if you have any final statements.
Thank you, Hillel. I would make a couple comments on the copyright registration. Absolutely. It's a requirement for compulsory mechanical license payment. It's a requirement to bring a lawsuit in federal court. It's a requirement to terminate transfers of copyright. And so absolutely, if you represent artists, register your copyrights. And then on the sync side, I guess the only practice pointer would be if you're representing a film company or video, but primarily film and television, get your request in early. I've had situations where literally a major theatrical release was going to come out and certain sync licenses were not agreed to, and that's a problem. So with that, I want to thank Elliot and Hillel and Anna for this presentation, and I enjoyed it.
And Tim, your duties aren't over yet, because there's another question that just came in for you, which is from Gail D. And her question reads, as a presenter, what is a good source for more info on obtaining sync rights for live streams on different platforms of the internet? And how does it differ between the U.S. and foreign artists?
Well, the resources, again, a plug to my good friends Todd and Jeff. This is a good one. Another good one is Kana Music Licensing. And the labels, they all have people who understand rate structure and what to request and so on. And what was the second question? I apologize.
The second question is there a difference between the U.S. and foreign artists with regarding to obtaining sync rights for live streams?
Well, you still have to obtain the sync rights for live streams. The distinction I made earlier was in the U.S. we do have a joint ownership, which is a tenant in common right that any rights holder can grant a non-exclusive license without the consent of others. Whereas in Europe, you have to get all rights holders. So if your license would include the world, not just the United States, you're going to want to get all the underlying copyright owners to agree.
Thank you, Tim. So that is the end of the set of questions that have been entered in chat. We are now in the informal part of the discussion, and I see we have numerous experts here on the line. And so if anyone has a question or comment, we have Hillel, and we have Tim, we have the two authors. Go ahead, please jump in. Did someone have a question? If so, please proceed. If you do have a question and you are proceeding, you'll have to unmute yourself to do so.
I have a comment.
Is there anyone?
Yeah.
Please do.
But first of all, it's great to see everybody. I miss seeing you all in person, but that was really helpful. And I'm glad my brother and I listened in, so we don't repeat anything you guys said. But you really laid the groundwork. The foreign area, as you know, is somewhat complex and very different in a lot of ways. But we'll save that for next week. But I really enjoyed today. That was great.
Thank you.
Good to see you, Todd and Jeff, and I look forward to your presentation next week, as always. I would tell everybody on this call, absolute must to see Todd and Jeff, and also Stan Suture, and I think another presenter. I mean, just really fun and very informative. These guys wrote the book, literally.
Right.
Oh, and Tim, you get 10% of our sales.
Yeah, we weren't supposed to tell people that.
Howard will write up the contract. Or Hillel.
So there's another question that's been submitted via chat from Brian Berkowitz, and it's, if I write my songs and copyright them, and if I have my own publishing company for these songs, do I sign up with the MLC as a self-administered songwriter or as a music publisher?
I would say both, actually, but the application process actually allows you to enter the publisher information, and if it's the same payment information, it should all log in correctly there. So I think there's a blank there is a spot for self-published writers, and there is a spot there to list your publishing entity. So you should be able to do that. At the MLC.com. It's pretty easy to navigate because they built it in 2021 or 2020 as opposed to building it in 1990, like some of the other database, websites.
So I wanna,
everyone,
go ahead.
Oh, I'm sorry. Firstly, just thanks for everything. It's a privilege to be here with such legends. So as regarding the MLC, it's a blanket license regime for DSPs like Spotify and Apple Music and whatnot. But, breaking it down to the other level, which is, let's say I'm a songwriter. Traditionally, I had to get, a Section 115 license to cover a song, the Section 115 license being, lovingly referred to as the cover license. So Spotify is good and they're going to match whatever I do. But, the whole regime of me filing as the songwriter for a Section 115 license, the MLC just dispenses away with that. What does the songwriter itself need to do to clear their cover version to then upload to Spotify, or is that no longer a thing?
Well, here's right. So are you saying it's you're saying is a cover version automatically licensed when you upload it to Spotify? And my understanding is that it is. You don't have to secure another license. You just put the information on Spotify with your song, but under songwriters, you have to list the correct writers and publishers.
Right.
Right. So I guess the question is, and this is an interesting question actually, because previously with Harry Fox, if you were going to get a streaming license, you would have to pay for that streaming license with Harry Fox. So does the MLC replace having to acquire that streaming license? I believe so. I believe it's covered in the blanket license.
That I didn't get or pay for, but Spotify or Apple Music or the like.
They're paying the royalties, right? You don't have to pay for it. They're paying the royalties from the streaming revenue.
Right.
That's my understanding. Does anybody have a different understanding of that?
Tim, thoughts on that? Tim, I think you're on mute.
I think it's similar to a performance right, where if you perform a cover tune at a live venue, the writer is supposed to be paid, but you don't have to get a separate license to perform that song live. But you do
Tim,
need
you want
to videotape it, to record it.
Tim Matson, did you want to join in on that topic?
Yeah, I actually don't know the answer to that question. My assumption is yes, but I would defer to my learned counsel, Todd Brayback. I just don't know if it's automatically cleared. I mean, typically you have to give notice to obtain the compulsory mechanical. That's one of the statutory requirements if you want to record somebody else's composition, and it's got to be commercially released in the U.S. and so on. But I'm not aware that the MLC gives you that automatically.
Todd Brayback, did you want to chime in on that?
Yeah, no,
issue?
Unfortunately, I don't want to hazard I think I know the answer, but I don't want to throw it out, but I'm not totally sure. But the bad thing, because Jeff had my brother's on the board of the MLC, and he started an MLC board call right when this thing ended. So I'll pass it on to him, the question. He can.
Yeah, that would be, I'm pretty sure that it makes sense that it would be covered because there are so many different writers to different songs. There may be a license. There's people posting new music by the hundreds of thousands every day. I think it'd be very cumbersome for the streaming service to regulate that, and that the blanket license is one way to address that situation. So, similar to what I think that there's a blanket license for Facebook and Instagram at this point with music, although that was negotiated with the publishers, right? So it's an interesting question. My thinking is that it would be covered as long as you accredited the song to the right party.
Yeah,
right.
Yeah, Hillel,
Thank you.
I think everything's covered based on the blanket license,
Right.
and you have to really opt out of it. But everything's covered.
Mhm.
Is that also why the ISRC code is so important now for publishers? I don't know if you can hear my question, but is that why the International Standard Recording Code or the ISRC is so important now for small publishers and songwriters, because the MLC will help match those cover works to their work? So if you're covering something.
It's the ISRC code and the accredited writers. When you're grabbing an ISRC code, you don't necessarily have to put the writers into the ISRC code, but that would be, the Mechanical Licensing Commission would be, I think, keeping track of that database.
I've got a question.
So go ahead.
Howard, yeah, go ahead.
So I've noticed that when you do a search for on ASCAP and BMI recently, they've started to merge their databases into what they call SongView. So while we're talking here, I just did a quick search on a couple songs I know that are on SongView, and I see they're not on the new database. And I'm wondering whether that is something, if anyone knows, that the MLC is going to pick up and include in their database, or whether everyone that's on ASCAP and BMI is going to have to re-enter.
I think they're grabbing. Go ahead.
Todd. Howard, I think how it's set up. There are three primary databases that I consider right now. First of all, it's the SongView, the ASCAP BMI newly integrated database, which is very helpful. You got the MLC database, which is primarily, the starting point was all Harry Fox compositions. And then any new Harry Fox compositions will go directly into the MLC database. But people are registering outside of Harry Fox. You don't have to be a Harry Fox member. You're registering directly with but you have to register your songs directly with the MLC. And all the information, ISRCs, ISWCs, everything should be included. And then you've got the Sound Exchange database, which is like, so many, I can't remember how many millions of sound recordings. So, I think of those three, they're not integrated yet into each other, but I mean, those are the three sources I always go to.
Yeah, but I think the MLC is only working with Harry Fox. I don't think it's taking any information from the performance rights organizations. I think that's a separate database.
Correct.
Yeah.
More work.
Yeah.
So,
Elliot, I apologize. I do have to run, so I'm going to have to bug out. But thank you, everybody.
Wonderful. We appreciate your contributions. Thank you for being a part of this. Judging from the comments we're receiving via chat, it's been really appreciated by many folks. So we look forward to seeing you again, Tim. Thanks for sharing your expertise.
Sounds good. Thank you.
There's a question. Are you taking off as well?
Yes, but if there's one more question, great.
Oh, well, there is one more question. I'll just throw it out to the group of experts here. And in fact, it's a question from Dr. Juanitaulloa. And Dr. Ulloa, would you like to simply articulate your question directly? Feel free if you desire to, but it's related to mechanical licenses.
Oh,
Dr. Ulloa, did you want to articulate your question?
Oh, hello. Thank you, first of all of you, for this wonderful information. I'm not a lawyer, so I'm very grateful to all of you. And I happen, just as background, to purchase the Brabeck's books at over 15 years ago at a songwriting conference. So I'm sure I'm going to need an update. My question is, do I no longer have to get a mechanical license per song to cover, if I'm covering a song from Harry Fox, if we have this new system in place? Do I not need to go do that anymore?
So if you're going to create CDs or vinyl, you still do need to get a license, because the license for physical units is still administered by Harry Fox. However, for digital and digital performances, digital interactive performances and downloads, that will all be administered by the MLC. And it seems to us right now, I haven't heard anybody reflect an opinion otherwise. It seems to us that it is automatically covered in the blanket license. So you do not need to get a streaming license and or a download license. That I'm not 100% sure of that. You used to have to purchase a download license from Harry Fox as well. But we should double check on that and see if you need to still purchase a download license from Harry Fox. But physical and CDs, you do need to purchase that license, and that license is very reasonable. It's 9.1 cents per unit. So for 1,000 units, if you're doing a run of 1,000 as an independent artist, it's about $91 for a song.
Okay. Well, it's been digital in the past, and it's time to renew. So I'm holding off now till next Wednesday, with hopes you all will continue to address this issue.
Well, I think streaming is covered, and as far as downloads, I need to check on that.
Thank you.
Yeah.
Thank you for your question, Dr. Ulloa. And before we finish up here, I would like to give Liz Storm an opportunity to either reflect on what we've covered or to maybe preview some of the things that we'll cover next week. And I asked you to do that, Liz, partially as a way of acknowledging you and bringing you to the attention of the audience because of your extraordinary efforts in putting this together. All the experts who are speaking here today are here because they are acquainted with Liz. So we really have you to thank. But did you have any comments regarding the presentation, the content today, or the content next week, Liz?
I just want to say thank you to everybody who offered their questions and comments, and to the speakers and panelists that are participating today. And then next week, March 10th, from 12 to 1, we'll try to keep it reasonable. There's a lot of content here, but I appreciate going over the 2 copyrights on the sound recording and the the performance arts, and going over some of the royalty issues that are related to the underlying musical composition and the sound recording. So I think there's a lot of information here today. I think next week, Todd and Jeff Braybeck will do a nice talk with on performance royalties and the MLC board. I think Dan Millington from PPL UK will be able to provide some information from an international aspect. And of course, Professor Sucher can cover some of the open-ended questions and maybe go over termination and recapture and some of the issues that we have, trading outside and importing into the United States. So keep an eye on your international standard recording codes and your international standard work codes. And if you have any questions, please email Elliot or one of the participants today or next week. I know they're happy to help you and talk to you about this. So thank you again.
Great. Thanks, Liz.
Thank you.
Well, I think that's a nice way to close this. Thank you for tying it all up for us, Liz. And once again, thank you, Hillel, for serving as a panelist, and to our other panelists, Anna and Tim, Liz for organizing it, the International Law Section for hosting it, and you all for attending.
Thanks.
Yep. Thomas will be making the recording available soon. Thomas will be making the recording available soon. We'll send out a link to everyone who attended or who registered. Take care, all, and I'll just hang on the line in case there's any follow-up questions.
Thanks, everybody.
Loud round of applause.
Yay.
Indeed.